legal expert Marius du Toit is joining us now from Pretoria to discuss this matter. Marius, good morning. Thank you very much for joining us on Morning News today. I don't know if you've seen the latest news. What we are aware of here on our program, it looks like, according to Eric Mabuza, the lawyer of Mr. Tom Moyane, he might be asking for more time in the disciplinary inquiry, to which he was supposed to have responded comprehensively yesterday, according to Advocate Azar Bam. That's one process that we just want to explore with you. I mean, how should we read that if these reports are true?
Well, I think firstly we have to differentiate that we have two distinct processes here. The one process, of course, is the inquiry which is held by Judge Nugent, and that's, of course, to restore the dignity of SARS and to develop processes that could better SARS at the end of the day. And the other process, of course, being the disciplinary process that you're speaking about against Tom Moyane, which ultimately wants to dismiss him or to determine if there's serious misconduct. Now, from what I understand, Dali Mpofu has raised a number of objections. Number one, he had a problem with the constitution of the legal team that is being employed. He had difficulty with the fact that there were oral submissions that people were not allowed to testify, that everything was to be considered on paper, in other words, affidavits. And some of these arguments held water, but of course the judge wasn't too happy about that, and ultimately it was then referred back to him to make representations to the president, and of course the president has, from what I understand, also not agreed with him. So these processes have to continue. I understand he wants to have the one stayed whilst the other one is continuing, but I mean these processes are so distinctly different, even though they might overlap. They are distinctly different in the nature for which they were designed, that ultimately these processes have to continue, and there's a duty to have these processes completed as soon as possible to restore dignity to SARS.
Now, the reports we have this morning is that Mr. Tom Moyane's lawyer, Eric Mabuza, has said that he has written now to BAM, the advocate who's heading the disciplinary inquiry, to indicate that he needs time to consult Mr. Moyane over whether to challenge President Ramaphosa, Advocate Bam, or Judge Nugent, or all three in court over this decision that both processes must continue, because the president has decided that both processes must continue. How would this then play itself out, in your view?
Well, it's a difficult matter to guesstimate how it's going to unfold. I understand that at the end of the day, when you represent a client, you want your client to be as well prepared as you can be, because ultimately the end result is going to be that your client will lose his job. I mean, he's suspended presently, so Eric Mabuza obviously wants to make sure that everything is played out in the open so that his client's rights are protected as best as possible. And I think if he doesn't get his day with the disciplinary process being fair and giving him the opportunity to fully respond to everything, and he feels that his rights have been encroached upon of his client, then of course that opens the ground for review later on to say, well, listen, there was irregularity in the proceedings, or perhaps I didn't get a fair hearing. And ultimately, the advocate presiding over this process has to ensure that the disciplinary processes are fully being ventilated and fully followed, so that ultimately you don't want the matter to be overturned by the Labour Court later on because due process was not followed. So if his client has not been able to prepare fully, needs more time, and it's a reasonable request, of course you'd have to indulge such a request. But if it's just to delay process, we all understand that justice delayed is justice denied. And there's a duty to restore the dignity of SARS, and obviously you want these processes to unfold and be concluded within a reasonable time, and that's a speedy process. So delaying the process is not in SARS' interest, it's not in the chairperson or the person chairing the disciplinary process's interest, and it's definitely not in the person who's being charged interest. So you want the matter to be concluded. So I believe that the presiding officer will ensure that the rules are being adhered to, that the disciplinary code, which has been laid down for government employees, have been followed, so that the matter will not be overturned based on a technicality.
Okay, now from your legal expertise, could if Mr. Moyane advised his lawyers, Eric Mabuza, and said, no, I want all this matter to go to court. Is it possible that all these processes, you've been very clear about these two distinct processes, one being the disciplinary hearing, the other one being Judge Nugent's SARS inquiry, which is supposed to wrap up its work by November, from what we understand now. Could it be successful? I mean, could Mr. Moyane and his lawyers succeed in stopping everything by going to court, by bringing all of these things together? Is it possible, Marius?
Well, I believe, obviously you can bring an urgent interdict if you believe that at the end of the day, the process is materially flawed and you will not get a fair hearing. But I estimate that the process will be followed. I believe that there will be a verdict at the end of the day. And everything that Eric Mabuza is doing at this stage is, of course, aimed at the later process. So at the end of the day, he would want to make sure that when this matter goes to the Labour Court, or when the Labour Court has to consider whether the process was fair, whether the evidence was fairly adduced, and whether he had the opportunity of testing it, he would want to make sure that he ventilated his grounds for objection at the time when the hearing was done. Because it wouldn't make any sense to then suddenly at the Labour Court jump up and down and raise that I didn't get a fair trial, whereas you kept quiet about these things during the disciplinary process. So I'm quite sure that Eric Mabuza is doing his best to obviously ventilate these grounds to make sure that at the end of the day, when this matter comes before a judge, and I'm quite sure that this process is only in the baby's shoes at the moment, this matter is going to run its full course in all our higher courts, maybe ending up at the SCA eventually, that at the end of the day, he wants to make sure that everything is properly ventilated, properly considered, so that by the time it gets before a judge, the judge can see that his rights were affected from day one, and hence he didn't get a fair trial, or perhaps the evidence wasn't fairly considered, or his arguments were just swiped under the carpet and was unfair to his rights in defending himself in the disciplinary process.
Well, that answer, Marius, tells me that we're in for this for quite a long time. Thank you very much. That's a legal expert, Marius du Toit from Pretoria Studios, just giving us his views about the SARS inquiry and also Tom Moyane's disciplinary inquiry.